So, that then brings us to docket SB 2015-06, Invenergy Thermal Development LLC's application to construct the Clear River Energy Center power plant in Burrillville, Rhode Island. We have on the notice of open meeting indicated that we will discuss and rule on several motions to dismiss filed by the town of Burrillville and by the Conservation Law Foundation. I suggest we deal with again seriatim, town of Burrillville first, and then the Conservation Law Foundation. As to the motion to dismiss from the town of Burrillville, I don't think that there were any significant arguments presented by the town beyond what was in the original motion, which was a motion to dismiss based on the fact that the applicant had no water supply plan. The applicant did come up with a water supply plan. And I believe that the motion is moot. It should be denied.
I just want to add something. It's like, yes, the applicant has submitted us a viable water plan, but yes, we do have a number of questions on the water plan. So definitely the board will ask for more additional information on the water plan. So, but still, we do have a water plan. So I do second the motion.
All in favor?
Aye.
No.
All right, that brings us to the Conservation and Law Foundation's motion to dismiss. That motion was based on first, the absence of any water supply plan, but also raised issues regarding the completeness of the advisory opinion, resting largely on the contention that the applicant had not provided the information necessary for those. I would like to compliment the Conservation Law Foundation on, I think it was a very well done motion and presentation. However, I don't think that we should dismiss the application at this point based on that. There is now a water plan. And we have already discussed the possibility, the very strong possibility that we need more information on some of the advisory opinion in light of the new water plan. So I think that under the structure of the act and the case law, it's certainly dismissal could be permitted, but it's not required under these circumstances. And I don't think that it's appropriate to dismiss it at this point. I think we get overturned. So I would move that we deny Conservation Law Foundation's motion to dismiss.
just want to add, like, as we know, the burden is always on the applicant to prove that we need this facility, this facility is cost justified, and it will not result in any unacceptable environmental issues, and it will enhance the socio-economic fabric of the state. And all these things will be, should be basically discussed at the time of the final hearings. So again, I second this.
Discuss before you haven't listened to it.
Chair, before we vote on this, I'd also just like to make a few comments. I agree and obviously carefully read the motions and the arguments on all sides for the Burrillville's motion to dismiss and for the CLF motion to dismiss. And I think it's important for the process, our role here is we're not for or against the stand, is to decide how the facts and the evidence and the arguments in front of us should be determined given the statute and the regulation. That's our goal. It's advocates and public input are considered, but the driver for us is how we interpret how the law and the regulation apply to what's in front of us. So I want to make sure to say to CLF that I agree on many of the places where you pointed out problems and gaps, where you pointed out advisory opinions that aren't able to discuss or make negative conclusions. But when I look at the act, what it says to us is that the agency that makes the advisory opinion, that this board needs to consider those opinions as grounds for whether or not we denied application. In fact, it further talks in the statute about how we might accept, reject, or modify advisory opinions. So I think that you pointed out a lack of water plan. We now have one. Is it sufficient or not? That's determined in the hearing. You pointed out gaps in some of the advisory opinions. I think because of some of the new information, we'll need new advisory opinions, supplemental advisory opinions, and that will reset some time frames. But when I look at the remedy for some of the gaps and the problems, I don't think it's to dismiss this case. I think it's to get additional evidence on the record and hear whether or not the information we have in front of us meets the burden. So based on that, I also think I'll vote to deny the motion to dismiss because I think some of the issues that were raised in that motion need to be considered in the process and in the hearing.
So, all in favor?
Aye.
Very good. That brings us to the procedural schedule for any of the open dockets that we currently have. I would ask the coordinator and council, are there any things we need to discuss about any procedural matters about it? These dockets or other dockets? I'm not aware of any. I just want to make sure that if there are, we have an opportunity.
Madam Chair, before she answers that, I'm not aware. We have some motions that I think haven't been disposed of yet that aren't on the schedule for today. But I wonder, since we need to have these public meetings to have any kind of conversation, if we could talk about further where we are in terms of the time periods under the statute and in terms of the need for additional advisory opinions to get information about a new water plan, new elements of treating wastewater, traffic issues, some of the things that are raised through the changes to the application. Is that appropriate for us?
I think, well, we're talking essentially about procedural matters. So I think that it's all right for us to discuss them, even though we didn't specifically notice them. I'm looking at council, but if this is correct.
I think that you can discuss the schedule, the procedural schedule. However, the town has filed a number of very extensive data requests. I believe that you may want to review the responses to those data requests and determine whether or not you have any of your own or if any of the other parties do, and then schedule an additional open meeting to decide or to discuss whether or not you believe additional advisory opinions are necessary.
Yes, I definitely think we have to decide the question of additional advisory opinion in another open meeting that's properly noted. But I think we can say that we definitely need to schedule something going forward. But I think you're also correct. We need to review all of the materials that we currently have. And if we get any additional comments from the parties or from the public regarding matters that need to be covered in additional new or revised advisory opinions.
Do you know what's the timeline of those submitting the responses for that data requests? Approximately, something, I don't know. That's fine.
We just received a number of responses, and the town has also filed additional data requests. The responses are due.
I will just point out that under the statute, agencies have up to 6 months to give advisory opinions, and it sounds like we're not, I know that Mr. McElroy, when he was arguing at the hearing last week, provided at least his take on a number of the agencies. I certainly have opinions on the number of agencies that will need to either supplemental or new advisory opinions. So I think, and under the statute, the rules allow us to reset the time clocks, and I think all the parties agree that the timeframes in the statute are directory. There's no disagreement about that. So we need to schedule then another hearing to talk about the order of advisory opinion. Is that right, Madam Chair?
Yes. So, ask our coordinator. Is it possible that we can use, I don't have a calendar in front of me so much, but is it possible that we can use the March 2nd and or 3rd for any of that? And council, I would just say, will we have the bulk of the information in front of us in order to make those determinations about advisory opinions and what other information we would need if we were to schedule it by for March 2nd or 3rd?
Well, the data responses are due in 15 days. Whether or not those will be fully complete by then, I don't know. You can certainly make additional designations after that time. So you could schedule an open meeting and determine what advisory opinions you'd like to have designated. And then if more information comes and you believe that more are necessary, you can have another open meeting at a later date for additional advisory opinions.
So do we have a possible date going forward for that?
Yeah, yes, I have, we have time booked on the 3rd, but I also have Monday, March 6th available on your calendars.
I would just suggest, in terms of the public interest in both of the matters we're discussing today, that we do them on 2 different days. It gives the optimal seating for people and opportunity. So if you could work on one date for the E-183 and another date for a discussion of the issues and the advisory opinions that we'll need from agencies, whether supplemental or new. I think it would be smart to do it on 2 separate days, and I will let you pick. I think we have the opportunity to notice that any of the days you mentioned, right?
Yes, that's correct. And so I will look to schedule that on March 6th.
Great, thank you. Anything further? That's it. All right, thank you very much.
I'll move to adjourn.
Second.
All in favor? Aye.